people, what's up? Welcome back. I hope yesterday you guys have done with your you guys have watched the most important topics, and I hope some topics which you might have left, you have considered it, you have revisited it, you guys have now studied it again, and you are now sitting here. And I know most of you have been waiting for this particular session, that is your detailed case analysis, that is whatever the case laws that is there in our ICAI syllabus I have taken up here. So I will tell you what is the agenda of this. Now in our book, there can be, there are more than, 50, 60 case laws in our book. Some case laws will be very much in detail. For example, if you look at, say, Carlyle versus Carbolic Smoke Bowl Company, the case law is in detail. That is, our syllabus itself, they have given you facts, they would have given you analysis, they would have given you judgment, everything would have been the case in the case of Carlyle versus Carbolic Smoke Bowl Company. But whereas there are some other cases that they would have given one generic line, in the brackets they would have written the name of the case law. Now, the question was, should we consider such cases? Is it important or not? Now for you, you wouldn't know. They would have given you a line, but they would have just given you that particular case in that particular bracket. Now we do not know whether that particular thing is important for us or not, and what actually happened in that case law, and when should we quote. So what did I thought is, why don't I make a particular video for all the cases put together, that is everything in your book with background, meaning what happened in short, when this happened, and what was a judgment, and basically what was the rule that was derived out of this case law. So on that thought, this particular case law series came out, and so you can see these are the page numbers that is there in the book, and that is all the cases that is there in our book. So one request for all of you, this is something where I'm trying to work towards on. This particular product is not completely ready. We are trying to do, I'm trying to do something on this particular thing. So meanwhile, please don't ask for this particular thing. So I would be discussing everything, whatever is there. Please watch, the entire thing, but it is not yet ready. If it is there, I would have definitely given it to you. So this is something where I'm not willing to give it in the public domain directly as of now. So please watch, relax, whatever is required from your exam point of view, make best utilization of that part. But yes, please excuse me, wherever it is there, I will only give it to you. Wherever it is not possible, please don't. Please, I hope you guys understand. Yes. So with that, let us start, people. So all the cases have been divided based upon, it has been classified based upon the chapters as well as the units. So yes, let's start with Indian Contract Act. There are some cases where even I am also trying to see what is, because I have to give the complete background and everything. So this is how this particular case law has been done. Okay, yes, people. So let us start. The first one, people, State of Gujarat versus Ramanlal Co. You can see here, key principle, meaning what was derived out of this case law. Facts, what happened. Analysis, what the court discussed and that day what happened. Conclusion is, what was the final verdict given by the court. So this is how we are, planning to do. But yes, State of Gujarat versus Ramanlal. In this case, what happened, people? There was ABC partnership. The partnership was getting dissolved. So in the partnership, there will be lot of assets, right? So after the partnership firm gets dissolved, what will happen to the assets? The assets, of course, will be shared amongst all the partners. Don't you think so? So A, B and C will take those assets. Now what happened? When the assets were getting transferred to the partners, there was an officer, that is a tax officer, IT officer, you can take it as. The income tax officer considered this transfer of assets from the partnership to the partners. he said this will amount to a sale. It's a transfer. And hence, as per our tax terminologies, we have to pay tax on it. So Mr. A has to pay tax, B has to pay tax, C has to pay tax on it. Because we are transferring the assets from one person to another. ABC is the person. No, for a partnership firm, you are transferring it to another person. But in this case, it was decided, people, that remember, a partnership firm is never considered as a separate legal person in the eyes of law. From time beginning, from first to second, we will be telling that partners and partnership firm are one and the same. They are not two different individuals. And hence, in this case, a contractor, there has to be two parties. Partnership firm cannot be considered as one party because it is not different from its partners. And based on this grounds, people, this was not considered as a sale. So legal principle, two things you guys can consider here. Separate legal entity. Partnership firm does not have a separate legal entity. Hence, it cannot be considered as a person. And hence, there are no two person in this contract. There is no two person in this transaction. And hence, you cannot have a tax on this. Was what discussed in this particular case law. That is State of Gujarat versus Ramanlal Co. Simple. People crazy. Yes. Clear. Okay, that is our first case law. Next one. Balfour versus Balfour. What is a legal principle? The legal principle is, people, legal intention to create or intention to create legal relationship. Husband and wife. Husband had promised to pay some monthly payment like a pension or your allowance. Every month, the husband had promised wife that I will take care of your monthly allowance by sending you, let us imagine, 5,000 rupees every month. A husband gave a promise to a wife. As promised, husband also gave 5,000 rupees for a period of 3 to 4 months. After that, the husband stopped transferring this money to the wife. Now the question is, people, the wife said, husband had given me a promise that he would transfer 5,000 rupees to me every month, but he stopped transferring. There was a promise that he would transfer 5,000. I gave an acceptance. Now he has stopped transferring and hence he has to transfer it to me. If not, it is a breach of contract. So he stopped. The wife went and filed a case on the husband because he stopped paying the money. Now the question is, people, in front of the court, can I even take up such cases where a husband promises something, a wife promises something? Can I take up such cases in the court? In this case, it was decided that, people, always remember, in case of domestic and social agreements, in between people, they keep exchanging hundreds of promises. Not all the promises they intend to fulfill. Amongst friends, you guys will be promising 100 things. Not everything can be taken up by the court. Now we have to consider these things as domestic or social agreements where you guys do not have an intention to create legal relationship. You never meant to file a case on one another when you guys entered into a contract. And in the court, the case was held in the favor of the husband, saying that, see, not every case the court can take up because these are domestic agreements. Not every promise you were serious. You did not intend to always fulfill all the promises you make. Certain are nonsense, like you guys give it in the class. Sir, this time we are only the toppers, sir. After 10 days, you also won't come. Class only will not come. Forget topper. Now, can I come and file a case on you in that regard? Answer is no. Yeah. So domestic and social agreements, Balfour versus Balfour. Intention to create legal relationship. The main thing is social arrangements or domestic arrangements. Clear? Done. Lalman Shukla versus Gauri Dutt. What is this? The main thing that happened here is, people, whenever a person asked one person to go and let us imagine this person had a missing dog. Yeah, I'm just telling you in easy way. I'm not or okay. Again, that also you guys will do on controversy. This person had a missing, let us imagine his son was missing. So what did he say? He went and asked his maid, can you please go and search my missing son? He said, okay sir, anything for you. The maid went and started finding the son. Now in between this person, the owner was also not sure whether this person will do a good job or not. So what did he do? He also gave newspaper advertisements. He also printed some flyers saying that anyone who gets my son, I'll give them a reward of 1 lakh rupees. After 2 days, the maid actually found the missing son. So the maid gave back the son and he went back home. Later in one of the place, he saw an ad that the owner had given an ad. Whoever finds my missing son will be entitled for a reward of 1 lakh. So the maid went for asking for the 1 lakh rupees reward. Now the question is whether the maid will get that 1 lakh rupees reward or not. The answer is yes, the maid will not get the reward. The reason is, remember, yes, you are thinking that, sir, you are cheating. No, people, always read the law as law only. Do not see it with your heart. You have to see it with your brain only. The maid was not aware of the offer at all. Now, in the court, if the maid can prove, I was aware of the offer, yes, the maid will win. But in the court, people, it was proven by the owner that when I told him the condition, the award was not yet decided. So he was not aware of the offer. He agreed to find the missing son even before he was aware of the offer. So he cannot claim the offer. And the legal principle here, people, is always what? It is, remember, the person to claim a contract, to claim an offer has to be communicated. If you are not aware at all, then how can you fight? Yes or no? So, communicated knowledge of the offer is important. If that is only not known, you cannot fight. That is a case law done. Harvey versus Facey. What is Harvey versus Facey? Also called as bumper hall pen case. Simple. One person liked another person's land. The land is called as people bumper hall pen. In various places they would have said pen means pen. It's not pen, people. Bumper hall pen is a name given to a house. So one person wrote a letter to another person. Would you be interested to sell your building to me? So this person replied, people, he said, would you sell your land to me, meaning building to me, and what will be the best possible price that you would be selling your land for? This person, so there were two questions. Will you sell your land? Next one, people, what will be the best possible price? He just replied for the second question, the best possible price is 900 pounds. I replied 900 pounds. That's the best possible price. Now, A replied, I'm okay with the price. Thank you so much. When can I come and collect the keys? This person replied, I never wanted to sell you. You asked me what is the price. I said 900 is the best possible price. He said, no. I clearly said if you are interested, you have to say what is the price. When you said price, that means you are giving your acceptance. So he started fighting for it. In this case, it was decided, people. Remember, when there are clearly two questions asked, just giving a price does not amount to an acceptance. So mere quotation of a price is not a contract. It does not amount to an offer. It does not amount to an acceptance. A clear yes or a no should be there. Just me telling a price cannot be considered as acceptance. Harvey versus Facey. Yes. So no contract arises unless a clear offer is made and accepted. Mere quotation of a price is not an acceptance. That is the main principle you need to write. Is this clear? Cut, copy, paste cases. MacPherson versus Appana. Cut, copy, paste. See, as in Harvey versus Facey, same thing happened here. The owner of a house stated that he would not accept less than 6,000 euros. So same thing, I wanted to sell my land. The other person said, what is the best possible price? This person said that I will not accept anything less than 6,000. So the other person said, then okay, I'm okay with 6,000. I said I will not accept anything less than 6,000 doesn't mean that I'm okay to sell at 6,000. I said if someday something comes, I will not go for less than 6,000. So these things cannot be considered as an offer. It has to be clearly communicated. No contract arises until offer is made and accepted. Same, cut, copy, paste. Now, sir, people, you guys would be having a confusion. Should we follow Harvey versus Facey or MacPherson versus Appana? Which one should we follow? Facts are same, scenarios are same, conclusion is same. You can ignore this. That's why in our books we would have popularly followed Harvey versus Facey. That's the logic. Understood? Okay, done. What is this? Harris versus Nickerson. An auctioneer advertised that certain goods would be sold at an auction. The plaintiff travelled to attend the sale, but the goods were withdrawn. See what happened? I have given an advertisement in a newspaper that the auction will take place from 10th of September to imagine 13th of September. There is an auction. So one person came all the way from Delhi to participate in this auction. But people, the auction was finally withdrawn. On 10th people, there was no auction held. So the person filed a case on the person that there was an offer and this person did not, what does that say? But the goods were withdrawn. Or you can take it like this. Imagine on 10th of September, I wanted to sell 10 items. In that I sold only 8 items. 2 items I did not sell. So a person who came to participate in this auction, he came for those 2 items only. By looking at an advertisement. But the question was people whether is this person liable for that person. First of all, people always remember, I hope now your mind is running, how to write the case laws. Yes, people, as you guys rightly said, the case law will come. What? It is just an invitation to an offer. We are calling you to participate in the auction. I am nowhere liable to the articles now. I have told I will be selling it. Can I recall it? Yes, revocation of an offer can be done before acceptance. It is my choice. Are you getting the point? See, I gave an invitation to an offer. Just by coming here, is it an acceptance? No. In the invitation, in the bidding, if at all you want the highest bid, then the acceptance will come into picture. I hope this is clear, all of you. Understood? That is what was held in Harris versus Nickerson. So withdrawal does not amount to any breach of contract because a contract has not yet come. A tender, advertisement to a tender is just an invitation to an offer. Simple. Bolton versus Jones. What is the principle? Specific offer, specific acceptance. A specific offer can be accepted by a person to whom it is made. A gave an offer to B. So B owns a shop. A said I wanted certain items and he wrote a letter to B. Can you please sell these items to me? B sold his shop to C. So next day morning C opened the shop. So C saw the letter written by A to B. So it is his shop now. So C sent the goods to A. Now C after 2 days asked for money with A. A said I will not be liable to pay because there was certain dealings between A and B. There was certain dealings with us. Why did you come in between? Now the question is people, can C recover money from A? Answer is no. Because this is considered as specific offer. When A has clearly written an offer to B, it is B's responsibility and not C's responsibility. Specific offer can be accepted only by a person to whom it is made. Bolton versus Jones. But remember, C has a right to recover the money from B. Always in your classes, when you guys are reading, you always will have this confusion. Sir, then Papa knows Sir C. People, I'm not saying that this person will not get money at all. He will of course file a case on B. He will recover the money. But not from A. A is nowhere relevant. Because with them they had some other private dealing. Are you getting the point? All of you? 100%? Case law Bolton versus Jones. specific person cannot be accepted by someone else. An offer made to a specific person cannot be accepted by someone else. Done. Next one, Carlyle versus Carbolic Smoke Ball Company. A general offer, open offer can be accepted by any person, public at large. Anyone can accept it. And remember, acceptance need not be communicated. Following the instructions given in the advertisement itself will be considered as an acceptance. In this case, what happened? There was a company who gave an advertisement in a newspaper that if at all anyone who uses our medicine and if you still end up getting up that time, there was something called as influenza like COVID. Imagine, I will tell you like today's scenario. If a company comes and says, you take our tablets like a immunity tablet, even after taking, if you get COVID, then they are telling you that we will be responsible. You will be eligible for a reward of 1 lakh rupees. So there is an innocent buyer who goes and purchases those medicine, who takes the tablets as per the instructions given. One in the morning, one in the night. He took it for 20 days. After taking also people, this person ended up getting COVID. Will he have any right? Answer is yes. This is called as what people general offer. General offer means when you give a newspaper advertisement, whoever reads it and who acts upon it will be eligible to get that particular benefit. Remember the difference between this and Lalman Shukla versus Gauri Dutt. In this person was aware of the offer. In that he was not aware. And you acting as per the instruction. What is the instruction here? Take 2 tablets, one in the morning, one in the night. That itself is an acceptance. It need not be communicated. That is Carlyle versus Carbolic Smoke Ball Company. Is this clear? Done. General offer. Next one, people, Neil versus Merit. What does that, people? Always remember, rules of acceptance says that the acceptance has to be unqualified. Meaning what, people? The acceptance should not have any conditions attached. Meaning what, sir? If at all I am saying, I want to sell, A wants to sell his car. In this case only I will tell you, A wants to sell his car to B. At what price? A wanted to sell it for rupees 5 lakh. Now what did B say? B said, yes, I am okay with it. He also gave 1 lakh rupees as an advance check. And he wrote a letter saying that the rest of the 4 lakhs I will give you in 2 installments of 2 lakh each. I will repay it within next 2 months. Is it okay? So 5 lakh I have agreed. But I am telling 1 lakh I will give you now, 2 lakh I will give you next 2 months. Now is this a valid acceptance? Yes, you guys rightly said it is not a valid acceptance. Why? Why na? Because think. Because I just said I want 5 lakh. Did I ever mention you that you can give me 1 lakh now, another 2 lakhs next month? Did I ever tell that? No. So this is what is called what? Conditional. This becomes what? Counter offer. Qualified acceptance is always counter offer. Now you are saying I will buy your car provided if it is sold in EMI. I should be okay with it. Now yours become offer. I should give an acceptance. That is this case law. Qualified acceptance is never a valid acceptance. Acceptance should always be unqualified, unconditional. That is the word. So these are the provisions. If you find such things in your book, in the question if these stories are coming, then you have to quote these things as valid case laws. So when we are writing our exam, I told you last day in our Mission 80, I told you that I will tell you how to present your answers. In that I will show you how to present when we have similar case laws. Clear? Okay, done. Now, what is this? Counter offer. Union of India versus Bahula. In this case, what happened, people? A wrote a letter to B. A wanted to sell the land. I asked, let us imagine. A wrote a letter to B saying that I want to sell my land for 30 lakh. Are you interested to buy? B replied, people, yes, I am interested to buy, provided if you sell it to me for 24 lakhs, I will buy. Now, of course, this is called as counter offer, conditional acceptance, negotiation. So the first offer came to an end. Counter offer is So always first offer comes to an end. Now it is A who has to give an acceptance, whether I'm okay with 24 lakh or not. Now in this case, what happened, people? A was not okay with 24 lakh. Now B later on, after 2 days, said, okay, I'm okay with your initial offer that I will buy it for 30 lakh only. Now the question is, people, is this a valid acceptance? Now is this a valid contract? That was the question. Yes, people, this is a little tricky. The answer is it is not a valid acceptance because when a counter offer was made, the first offer came to an end. The first offer is done. There is no longer that is existing. Because of your counter offer, that offer came to an end. Now your 30 lakh itself will become a new offer. Now A will have to say yes to it. That is this case law, Union of India versus Bahulal. What does it say here? Once an offer is rejected or a counter offer is made, the original offer cannot be revived. The same thing cannot come back except by the offerer. No contract exists until the offerer accepts the counter offer. Now A has to accept that. Here all of you. Yes, nice one. Next one, Brompton versus Metropolitan Railway Company. Same thing, people. This is opposite to Lalman Shukla case. What is that? In Lalman Shukla, offer has to be communicated. In this, people, acceptance has to be communicated. A simple thing, a company wanted to approve a certain company as their raw material vendor. Let us imagine there is a company A. We wanted to give a contract to a person, that is B, to supply raw materials to us. So company B gave us a quotation that this is what will be the price. So in company A, there was a manager. The manager saw the quotation and he wrote approved and he kept it in his drawer. Now the question was, offer was made that raw material 1 kg will cost me 1000 rupees. I said I'm okay with it. I approved it. But where did I keep it? I kept it in my drawer. I never gave it back to Mr. B. Now the question is the contract coming into picture? Is the contract existing between A and B? Yes, as you guys rightly said, there is no contract between them. Why? Logically think. B does not know what you did with that paper. Allah, you wrote approved, you went and took Belpuri, Anna, you gave and you ate something. How do I know what you did with that paper? Understood? Acceptance must be communicated. Brompton versus Metropolitan Railway Company. Done. What are all names are coming? Okay. Sir, Bhagwan Das, Govardhan Das, Kedia versus Girdarilal, Parshottam Das and Co. My God. 1966. In this case, what happened, people? The appellant, now see, it's a nice, different one. People now see, if you see all these cases now in our book, we will not have complete facts. But because the case is there, a scenario may come. So that's why I thought, okay, because the words are there, let us look into the case and let me explain you at least in short. Now when they are asking you, remember this, okay, it is something there. And from your end, at least put little effort. See, I have paused it for a while. You can take a picture, you can take anything that. Take a minute to write a note, please. Yes, can you guys do it? Please show me your cooperation. Say cheese. Very good. Achhe pyare bache. People, okay, in this case, what happened, people? See here. Whenever, see, the contracts can happen in 3 ways. One is when people are standing right next to each other, easiest way of contract. Next one is by posts. Third one is by telephone. So in a telephone contract, what will be considered as place of contract? Like, let us imagine a person from, if you guys remember in most important topics, I have given this also. A is in Bangalore. I'll take the same example I was given in most important topics. A is in Bangalore. B is in, I think I have taken Hyderabad. B is in Hyderabad. A gave a call to B, I want to sell my car for 5 lakh, are you interested? B said, yes, I'm interested. I will buy your car for 5 lakh rupees. Now the question is, what is considered as the place of contract? Is it Bangalore or Hyderabad? Why is it important? Tomorrow imagine if there is any dispute between you guys. Where will you guys go and fight? Is it in Bangalore's courts or will you guys go and fight it in Hyderabad's court? Where will you go and fight? In this case, it was decided wherever acceptance is received will be considered as the place or the jurisdiction of that particular contract. Now, where is acceptance received? Acceptance is received wherever A hears, yes, I am interested. So, in Bangalore, I am hearing, correct, that is what they are telling you. The respondent accepted. When the appellant failed to take delivery, the respondent should, the telephone conversation is instantaneous form of communication. Unlike postal communication, acceptance is effective when and where it is heard by the offerer. Therefore, the contract was concluded in Ahmedabad and the courts there had jurisdiction. So, Ahmedabad here is in our case is Bangalore. See, complete when the acceptance is heard. Clear, all of you? Pakka. So, wherever I hear the acceptance will be considered as a jurisdiction of that particular contract. Done. Simple case law. Done. Next one. What is that? Hayworth versus Knight. This is not a very good one. We do not have much in detail. This is nothing but people. Minor variations in the wording of an acceptance that do not change the substance of the offer, do not invalidate the acceptance. What do you mean by that, people? Now imagine, people, I'm selling you my car for 5 lakh rupees. I'm telling you, I want to sell my car to you for 5 lakh rupees. Now you reply to me saying that, people, I want to buy your car for 5 lakh rupees as told by you. Now what is that? I'm not actually accepting in the same words as you said. I might be adding 1 or 2 words here and there, but the meaning is not changing. Meaning I'm not adding any conditions to it. Sir, did not understand. Meaning, your exams are, they're expecting you to write what is voidable contract. What will you write? Voidable contract means a contract which is valid or invalid. Correct? Meaning is same. But what are you expected to write? A contract which is voidable at the option of one party but not at the option of other. Meaning is same. Intention is same. But the way you are communicating is different. They are telling you in this case, as long as the intention is same, the words, if at all here and there 1 or 2 words are getting added, that will not amount to cancellation of a contract. It will still be a valid offer. It will still be a valid acceptance. But I am not telling you it should be variation. Variation means it will become qualified acceptance. Wordings can be different. It is okay is what was discussed in this particular case law. Not so important. Okay. If you are planning to remember so many cases what to do, this is okay. You can leave it. Next one, Feldhaus versus Bindley. What is Feldhaus versus Bindley? Silence cannot be considered as acceptance. A told B that I want to buy your car. If I do not listen anything back from you, I will consider it as an acceptance. So such things cannot be valid acceptance. Acceptance has to be either orally, written or by conduct. You should say something. Sir, the offer cannot have a term that if you do not accept, I will assume that you are accepting it. So that is what was discussed in this Feldhaus versus Bindley. Same thing in the case car put horse. So one person said if you do not say anything, then I am assuming that you are interested to sell your horse to me. It cannot be considered as valid acceptance. Next one. I hope you guys are understanding that. Hey, let me know. Central Bank of India, Yacht Mall versus Venkatesh. Mental assent or uncommunicated resolution does not amount to acceptance. Acceptance must be communicated to the offeree. Same thing. A bank resolved to sell land to A but failed to communicate its decision. The court held that merely passing a resolution did not create any contractual obligation since the resolution was never communicated. Meaning what? Imagine in a bank auction, one person had taken a loan and he had taken a loan on a property and this person does not repay the loan. Now what does the bank decide to do? The bank decided to sell that property in an auction and they decided also in the bank. They passed the resolution. Let us sell off this particular product. Let us sell off this particular product. This is more clear. This is more clear. Hello. This is clear? Yes. So the bank passed the resolution also that let us sell off this property, but it was never communicated to the other party. So same thing was discussed and decided in this case law also. As long as it is not communicated, you cannot assume that there is a contract. Always it has to be communicated. Acceptance should always be communicated. Here. Okay. Planning to remember, you can leave it. Enters Limited versus Miles Far East Corporation. Cut, copy, paste whatever was discussed in the case law of Bhagwan Das, Govardhan Das, Kedia. In this case, what was decided? Whenever instantaneous contracts, meaning what people, whenever it is over telephone, wherever you receive will be the place of contract. Cut, copy, paste is this. Nothing will change. Can you see this? Clear? Same? Done. Mukul Datta versus Indian Airlines. What is this, people? Nothing but special conditions. People, for this we would have seen this case law in our class. Lily White versus Manuswamy. What is this case? Remember people, whenever in a contract, you'd be entering so many contracts, right? Like for example, I want to travel in a flight. Now, behind the flight ticket, of course, now everything is electronic, things are changing. But at least if I go back 5 years, I used to get electronic tickets. I used to get physical tickets. Now the question is, whatever is given in the tickets, you guys would have never read it. Are those conditions binding upon me? Does it bind me? I have not read it. Will it bind me? The answer is so will it bind me? That was a question, right? Will it bind me? The answer is, people, always remember, if the conditions printed on the tickets or any place, you go to a movie, you go to a shop, you're getting an invoice. If the conditions are reasonable, then it is binding you whether you have read it or not. And that is what is considered as special conditions. So if I have to combine Mukul Datta versus Indian Airlines and Lily White versus Manuswamy, the verdict, conclusion is same. If there are any special conditions printed on a ticket and if they are reasonable, then it will bind the parties. Exactly that was discussed in Mukul Datta versus Indian Airlines. So a person was traveling in a the aeroplane. So in that, whatever tickets, he said there are some conditions. After everything happened, that this person said, I did not know. The aeroplane said, of course, you guys, it is printed on the ticket, you are liable. It was discussed finally in the court. It was decided that if it is printed on a ticket, you are liable. There is no going back. In Lily White versus Manuswamy, other way around. It was printed. One lady gave her sari for a laundry. The laundry people ended up missing that sari, but on the ticket it is written, if at all we miss your sari, if we make your product unfit, or if we make your product unusable, in such cases you will be entitled for a compensation at the rate of 15% of today's market price. Whatever is the value of that product today, in that 15% will give it to you as compensation. In this case, court decided and said, special conditions, people, if at all it is unreasonable, then it will not bind you guys. Then you need to claim something more as compensation. So special conditions, but if it is not, valid, if it is not reasonable, then it will not bind the parties, was what discussed and decided in Lillywhite versus Anuswamy. Okay, what is this? What is this? Raipur Transport Company versus Ganesha. What is that, people? Okay, imagine like this, people. ArivuPro sells our classes to the students. I don't know if I can give this example or not, but we shouldn't actually. But yes, for you to understand better, I'm telling you. ArivuPro, we sell our class to the students. Meaning what? Let us imagine I take admissions for CA Foundation and CA Inter. Now we have clearly told people while we are giving you an admission, people, if you miss classes, if you miss attending the classes, you guys will get the access for recorded videos. If you miss also, you need not worry. You can still watch it on a recorded content. Now, what will students start doing? Here and there, they will start missing the classes wantedly without reason. They will end up piling the syllabus so much that they can't watch recorded videos also. Now, what will ArivuPro do? After you guys join, now sale has happened. We said if you miss, you can watch recorded videos. After you guys have purchased, you have come to the classes, you have sat, on day first, on orientation, we will tell you. So now what I'll do, once again, some problem. So now what we will do on day one, orientation, what we will do, I'll only tell, if you guys miss classes without proper reason, we will say, if 60% minimum attendance is not maintained, we will not give you recorded access at all. Now the question is, people, is this condition binding on you guys, on students? Can they say that no, it is not binding, or can we say, hey, it is our discretion, we can impose any condition? The answer is, people, technically, don't tell to anyone. Yeah. People, and don't tell management I told this, example purpose I'm telling you. People, this will come under conditions imposed after contract will not bind the parties. After the contract is made, if at all you want to enter into any new terms and conditions, it has to be always with mutual agreement. So this can we do? Answer is no, is what was decided in this case law. Special conditions inserted after a contract is formed are not binding. Pakka, what this case law is. Done. Okay. Next one, sir. Ramsgate Victoria Hotel Company versus Montefiore. What is this case law, sir? Okay, in short, I'll tell you. There is a person called Mr. A and there's a company called Ramsgate Victoria Hotel. Victoria Hotel people, they came up with, let us imagine, something called as IPO. They wanted to sell their shares to the public. One of the person, yes, people. So now in this case, what happened? There is a person who applied for IPO. Say, for example, on 1st Jan 2026, he applied. The company never allotted the share to this person. Allotment meaning the acceptance was not given. So now in this case, the question is, people, on 1st Jan he applied. Even by end of Jan, they did not give allotment. End of Feb, they did not give allotment. End of March, they did not give allotment. So this person thought, people, it is done. But somewhere in the month of June, yes, people, we were doing this case law of Ramsgate Victoria Hotel Company versus Montefiore. In this case, what happened, as I told you, a person applied for an IPO on 1st Jan 2026. The company did not give an allotment even on 1st of Feb, 1st of March, the allotment was not given. Now the question is, people, whether okay, in until 1st of March also it was not given. Now what did the company do in the month of June when the market price is down? So imagine if the face value is 10 rupees, the market price that time has become 5 rupees. That time, people, they gave allotment to this person. Now this person is rejecting the offer, saying that you cannot give an allotment after 6 months after IPO has come into picture. Now the question is this valid acceptance by the company or not? They gave an acceptance in the month of June. So in this case, it was decided, people, acceptance must be communicated within reasonable time. So whatever the IPO allotment the company gave in the month of June is not considered as reasonable time. A month or 2 maximum can be considered as reasonable time, but not 6 months or 1 year cannot be considered as reasonable time. Cut, copy, paste, Ramsgate Victoria as well as Indian Cooperative Navigation and Trading Company Limited versus Padam Se Premji. Cut, copy, paste. Yes, allotment was invalid because it was made after unreasonable delay. Simple, done. Next one, sir, unit 2. What is this? Unit 2. This is nothing but, people, Misa versus Curie. In this case, it was held, people, consideration can be a positive act as well as a negative act. That is, it can be to do something or abstain to do something. That is what was this case law. So, someone said, I will give you money to discharge the debt of a person, was also considered as valid consideration only. Exam point of view, I would say still okay, but what is the main point here? Abstain. That is, it can be positive as well as negative. That was the main verdict of this particular case law. Till now, people, I was sitting up, we were doing no, this is proper Ganesha mantra. We speak, 100 speakers will come and say Tamte Dankanaka. So, that is only going on, but yes. Yes. So, after that only we started, but yes. Okay. How much of inconvenience, no? It is good as well as bad. Now right in front of our academy, one road is there. Complete road is blocked. So, in my childhood also, we also used to do, I'm not saying no. But the population then was different. Today's population is different. So much of inconvenience will be caused. But yes. Next one, people. Durga Prasad versus Baldio. What is that, people? Consideration must move always at the desire of the promiser. A told B to construct certain shops. A told B to construct certain shops in a particular city. B constructed those shops as well. Now, A told B, you construct shops in the city and you charge rent for it. Now, B started charging 2 rents. One is to use the place, 1 rent. Next one, he constructed the shop for them. No, he started selling another, a percentage as commission. Because I've spent so much of money, no. For you guys, I've done it, no. So for that, you pay me an extra on your sales. You pay a particular percentage as commission to me. So one is rent and one is commission. Until one day, people, where one person came and said, why should we pay you commission? Did we ask you to build? So a person, C, who is taking the shop on rent is coming and saying, did we ask you to build? Rent we will pay because we are using it. Why should we pay this? In the code, it was decided, people, consideration should always move at the desire of the promiser. C never asked you to build the shop. So you cannot claim for construction also you have to pay a particular rent. That is not allowed. That is not binding on the other parties because they never asked for it. Durga Prasad versus Baldio. The key principle is, people, what? The consideration must move at the desire of the promiser. Done. Chinnaya versus Ramaya. Consideration may move from the promisee or any other person. A old lady said, I will give you my properties. All my properties, I'll give it to you. Chinnaya said to Ramaya that I'll give you all my properties. I have only one condition, that I have one brother. You have to give him every month some pension for his monthly living. She said, okay, I will give. After promising, people, she said, this old lady passed away. They gave the property and passed away. But Ramaya said, going forward, I will not give you even 1 rupee because I am giving you pension. What are you giving me? There is no quid pro quo. But in this case, Chinnaya said, whatever my sister gave, that will be a consideration on behalf of me. So consideration may move from promisee only or any other person. It will be a valid consideration. This is clear. That is what was decided in this particular case law. Next one, Kedarnath versus Gori Mohammed. So in this case, what happened, people? I think I told you in the most important topics also. What is charity? You agreeing to give. Imagine Mr. A saw one advertisement on Instagram that one particular child is suffering from cancer. So A said, I will give, he messaged, I will agree to donate 10,000 rupees towards this particular patient. So like that, lot of people started doing it. So the people who were collecting the donation, they decided to go and admit that child to a hospital and they wanted to get the treatment done. Now this person saw the treatment. He saw that, okay, everyone have already given money. Lot of people have agreed to give money. Now why should I give 10,000 rupees? He wants to back out. Now the question is, in a charity, will it bind you or will it be considered as a valid contract? Remember people, in a charity, depending upon your word, if someone has undertaken the liability, meaning they started the operation, they started the surgery, now people, you will be bound by it. You will have to pay whatever you have agreed to pay. So a charity, upon a liability being undertaken, will become a valid contract. You are bound by it. Kedarnath versus Gori Mohammed. Charity is the main principle. Okay, done. Unit 3, Mohari Bibi versus Dharmodas Ghosh. Most popular case law. A child went and borrowed loan from a major. He was a minor and the contract was considered as void agreement. And what was the verdict? A minor agreement will never be a valid contract. The courts will never help you at all. So the minor will be free from all the debts. But remember, there is also called as something doctrine of equity. Under this, yes, we will not protect. But if the minor has taken 20,000, if the money is there in the bank account, people, under the doctrine of equity, the courts will always tell the minor to return that money. But what if he has spent? If he has spent means, people, then karma. We can't do anything. But if the money is available, the court will always recover it for the person. Because we cannot make a misuse out of the law. Clear? Mohari Bibi versus Dharmodas Ghosh. Sain Das versus Ramchand. What is that, sir? In this case, there was one major and there was one minor. Together, they borrowed one loan. Whenever there is a joint agreement in which there is one major, one minor, minor will not be liable, but major will be liable. Joint promisors where minor and major both are involved. Minor will be free from liability. Major will be liable for the entire liability. Sain Das versus Ramchand. Key principle, minor agreements. Major will be liable in a joint contract. Clear, Ada? Okay. Next one. State of Bombay versus RMD. Samar Baugwala. Now in this case, what happens, sir? Simple people, nothing but wager. Crossword puzzle. Is it considered as wager or not? Simple people, if a winner is decided based upon luck, then people, it's a wager. If a winner is decided based upon skill, then people, it is considered as valid agreement. Provided, yes, the prize money does not exceed that 1,000 rupees thing and all will come. But yes, remember that. That is the solution which was decided. It was decided in State of Bombay versus RMD Chamar Baugwala. Simple crossword puzzle. Wagering is the key principle. Are you understanding, Ada? Hello. Done. Next one, Gibbons versus Westminster Bank Limited. In this case, what happened, people? I have told this even in your most important topic also. Remember, people, there is something called as vindictive damage or exemplary damage. It is always awarded whenever you fail to marry a person or whenever there is a wrongful dishonor of a check. Meaning, my account has balance, but the bank wrongfully said there is no money in my account. Now, whose account is this? Is this a businessman or this person is a non-businessman? If you are a businessman, people, by default, you will be entitled for exemplary damage. Revenge you will by default get. But if you are a non-businessman, people, you need to prove what did it affect and how did this wrongful dishonor affect your status. If you cannot prove, then by default, people, we will not be entitled for exemplary damage. By default, we will be entitled for nominal damage. Because there is no effect because of whatever dishonor it happened. We did not suffer any loss. So that's the judgment we take from this. It is clear. Gibbons versus Westminster Bank. Rochester versus De La Torre. What happened in this case law? There is a person called as A. He called B and he said, imagine this person is coming from France and this person is in India. He said, I'll be visiting India in the month of 1st June 2026. Can you be my tour guide from 1st June 26 to 1st September 2026? This person said, okay, I'll be, and they entered into a contract. This person called him on 25th May 2026 and said, I would want to cancel my contract. Meaning I don't want to go ahead. I would want to go back. Now the question is this considered as breach of contract? Because now this person is saying the contract has not started at all. The contract will start on 1st June 2026. It has not started at all. So people, remember, this is called as executory contract. You guys have agreed. Contract is made. Whether it has started or not, it is irrelevant. But you guys have agreed. So it is a breach of contract. So this tour guide will be entitled for compensation. This is an anticipatory breach of contract. Whether will I be entitled for compensation? Answer is yes, I'll be entitled for compensation. Anticipatory breach of contract. I will be entitled for compensation. Done. Next one, Frost versus Knight. Same thing. A promised B that after this person's father dies, I will marry you. He promised. But what did this person do? As long as his father was alive, he ended up marrying another lady. He married another lady. So it is so evident that people, I cannot marry her immediately now. So the law considered this as, again people, a breach of contract by conduct. You entered into a scenario in such a way that now you cannot marry her. You need not have to tell it. We know it by conduct. So now what she can do? If she wants, she can wait. It is left to her. Or can she file a case? Yes. What will she get? She will get exemplary damage. Frost versus Knight. A person promised to marry, she will get a compensation because of a breach of contract by conduct. Here, damages, exemplary damage. That's the case law. Shamlal versus State of UP. We have seen this also. What happened in this case law, people? The case is for a quasi-contract. Basically, what happened in this case law? Okay, so this person was working for one of the government. The government removed him from the job. He went to the court and got a stay order, interim order, that I should not be removed because there should be a hearing. The court also passed an order in the favor of this person. Yes, without hearing, you cannot remove that person. So the government took this person back into the job. So because he was taken back into the job, the government had to pay him salary every month. So they paid him salary for 6 months. Of course, simultaneously, the court case was still happening. The government was sure that it is going to win. The government did not allot even one single work to him in the 6 months. Now after 6 months happened, people, government won the case. The case went in the favor of the government and it was decided that yes, you can remove that employee because of these grounds. The government removed him and the government filed a case to recover this money under quasi-contract. and no one can take a benefit of something which he is not entitled to. 6 months you did not work and you were also aware of it. So because of this, it was decided that this person, Shamlal, has to return the money whatever he has taken as remuneration for which he has not worked at all. That is his case law. Done. Holland versus Howler. What is this, sir? Nothing but people, finder of lost goods. A person went to a hotel. This person saw a diamond ring. He searched for a owner he could not find. So he went and he gave the ring to a cashier. He said someone has lost it. So if someone comes asking for the ring, please give this ring back to them. So after 1 week, people, this person again came. A came and asked B, did you find the owner? Were you able to return the ring to them? The cashier said, no, we were not able to return because no one came in search of it. Now the question is, whom will this diamond ring belong to? A or B? Because the owner is not there. Remember, people, in this case it was decided whoever finds the product will be considered as the next owner. So A found the product. So whatever, let us imagine if this cashier has, spent some money to find the owner, like giving an advertisement or whatever. If he has spent some money, A will have to return that money to B and A can keep the product with him. Whoever found the product will be the next owner. But yes, you need to make sure when the owner comes, you need to return the product. Here are Holland versus Howler. All easy case laws, Noda. Hello. Shri Shiba Prasad Singh versus Maharaja Shrish Chandra Nandi. In this case, what happened, people? In this case, it was decided nothing but people. The case is again revolving around something called as mistake. The royalties were paid under a lease after a lease. In short, people, nothing but remember, if at all any money is paid by mistake, you will see this under quasi-contract only. If there is any money paid by mistake, whether it is mistake of law or if it is mistake of fact, any money paid by mistake, whether mistake of law or mistake of fact, that money is still recoverable under quasi-contract is what was decided in this case law. Exam point of view, okay, not that important, you can ignore. Sales tax officer versus Banaras versus Kanhaiya Lal Mukund Lal Saraf. In this case, what happened, sir? Same thing again. See, taxes collected under an invalid statute paid by mistake of law must be refunded. Meaning, in short, I'll tell you, people, A did a transaction. Let us imagine he entered into one contract. He did a transaction. There was a sales tax officer who said, this particular transaction will be levied a tax. There is a tax you need to pay. This person paid the tax also. But he said, how am I responsible to pay this tax? This does not come under that scenario at all. But the sales tax officer did not live, so the tax was collected. Later on, it was proved that people, for this transaction, the tax is not attracted at all. I need not pay. But the sales tax officer is telling, no, it was paid by mistake. And hence, next time you need not pay, but for this time it is valid, we will not refund you the money. The law was decided in the favor of this person. Of course, today, what is this exploitation? The law decided that no, whether paid under mistake of fact or mistake of law, money is refundable. Quasi-contract, yes, done. Next one, Seth Kanjelek versus National Bank of India. Again, people, what is this? Someone forced a person to pay money. So can I return it? Yes, people, under the words coercion. In this case, what was discussed was coercion includes a lot of things like extortion. What is extortion? Someone blackmailing you to pay the money. Even that is also considered as not valid. If at all someone has taken money from you like that, that can be returned, refunded. Quasi-contract only. Exam point of view, okay. Trikamdars versus Bombay Municipal Corporation, a person who pays penalty under duress or threat of prosecution. Again, in this case, what was decided is, people, let us imagine I'm going in a bus. I did not buy a ticket. Now a TC comes The ticket collector comes and he says that, where is your ticket? I said I did not buy. And the person says you need to pay a penalty. Penalty of how much, people? I need to pay a penalty of, let us imagine, 10,000 rupees. Yeah. I said I don't have money now. He said, if you don't pay money now, I'm going to put you in jail for 2-3 years. He said, sir, I understand I did not pay ticket. I did not buy the ticket. But I need some time to pay this. You can't say that if I don't pay now, I'll be put in jail and all. He said, no, nothing doing. If you do not pay the money now, then I am going to arrest you. Now, people, this person called so many people, he took so much of help and he tried to clear that 10,000. And after paying that 10,000, he filed a case against this collector, that is ticket collector, saying that the money was taken by him by force. He was not given a fair chance to pay the money. The money was taken by him by force. They did not give him a fair opportunity to pay. So this money, whatever was taken, was it valid or invalid? People, you will not believe, in this case it was decided that whatever the ticket collector did was invalid. Because you have to say that yes, you need to pay penalty. But remember people, penalties, whichever law, it will always come with a time period. And no one will be moving with 10,000 rupees in pocket. Of course. Now why is this coming under coercion? This was also considered as coercion, and the money was returned. The TC was suggested to return the money collected as penalty because it was not conducted fairly. Yeah, because even that is the duress, the pressure that you put is still considered as coercion. And it was decided in this case that you have to return the money. Logic understood, no, penalty is valid. I'm not saying penalty is invalid. But you need to give certain time period to collect the money. You cannot say that pay tomorrow, is what was decided in this case law. So with the fear of getting imprisoned, he paid immediately, can be returned back. Next one. Gajan Moreshwar versus Moreshwar Madan. Indemnity holder can sue the indemnifier. Meaning what, people? In this case, again, not so important. Meaning, imagine I've taken some insurance. I can ask money from my insurance company as and when I meet with an accident. As and when my bike meets with an accident. So whenever the liability arises, I need not have paid the money. I need not have got it repaired yet. But as and when the liability arises, I can go and I can ask my insurance company to pay me the money. So the indemnifier will be liable to pay the money to indemnity holder as and when the liability arises. Yes, sir. Not when the loss actually occurs, meaning I need not have paid. Liability happens, you will be liable. Done. State Bank of Saurashtra versus Chitranjan Ranganathan Raja. What happened in this case law, people? A principal debtor borrowed money from a bank. He took loan. And of course, bank also took something as collateral, that is security, pledge. Let us imagine gold. And there was also a there was also a surety. The bank, due to its negligence, people, they lost this security. So in this case, it was decided that the surety's liability will reduce by the extent the bank has collected that particular collateral. So imagine if the loan was 1 lakh. The bank lost a gold worth 50,000. The surety's liability will also be reduced by 50,000. Always remember, the surety's liability is coextensive with the principal debtor. And surety has a right over the security interest created by the principal debtor. So surety's responsibility will be to pay 50,000 only. Is this clear? Done. Hyman and wife versus Nee and Sons. In this case, what happened, people? Whenever the case is on bailment, and what type of bailment? Bailment is non-gratuitous bailment, also called as bailment for hire. In this case, what happened? A particular person took, let us imagine in today's scenario, a person took a Zoom car on rent. The Zoom car brakes were not working properly. So the question is, people, a person went and hit someone, so there is a liability. Is Zoom car liable? The Zoom car was not aware that the brakes were not working. So remember, in a non-gratuitous bailment, meaning whenever the money is involved, you have taken it for rent, the person will be liable for all the defects, whether known to him or not known to him. So Zoom car, whether they are aware of that there are defects in the car or not, Zoom car will be liable. Principal non-gratuitous bailment, that is bailment for hire. You will be liable for all the defects, whether known to you or not known to you. That's the conclusion. I hope you're able to understand. Great Northern Railway Company versus LEP Transport and Depository Limited. In this case, what happens, sir? Now imagine, people, there is a person, he sent certain goods via ship. So there was a certain goods sent by this person via ship. So like a consignment, you send, no, imagine some export is happening. Now people, this is a bailment, of course. Now, whenever you are bailing people, whenever you are giving certain goods on bailment, it is your duty to disclose if it is any dangerous or hazardous. This person did not disclose the nature of the goods. So the goods were kept in a normal way, that will be kept in a ship. But after it is being kept, people, it was known to the captain after everything was done that there were certain dangerous goods that were kept, because of which the goods around it has been spoiled, destroyed. It was held that the bailer will be responsible because it is your duty to disclose the dangerous nature of the goods. So whatever is the nature of the goods, you need to disclose as a bailer, is the case law. Done. Shantilal versus Tara Chand Madanna Gopalji. What happened in this case? In this case, people, simple. A person gave, imagine this person had some 50 bags of cotton. 50 bags of cotton. He asked Mr. B, can you please keep these cotton in your godown? He said yes. Of course, bailment now. Okay. While the goods were in the warehouse, that day there was a huge rain and it flooded. Of course, the 50 bags of cotton was destroyed. Now the question is, who will bear the loss? Is it the bailer or the bailee? Yes, you guys are right. It will be bailer's responsibility. Act of God. I have taken reasonable care. I have kept it in a warehouse. Even after that, if it rains, what else I can do? So act of God, something which is not in my hand, after taking reasonable care, even if some damage happens, it will be the responsibility of the bailer. Bailee will not be responsible. If I have taken proper care of the goods, I will not be responsible. Shantilal versus Tara Chanda Madan Gopal. Unit 9, last one of Indian Contract Act. Anoda Persad Roy versus Dwarkanath Gangopadhyay. Now in this case, what happened, people? Of course, as an agent, people, you need to give proper accounts to your principal. What do you mean by proper accounts? Proper accounts means the numbers, journals, ledgers supported by vouchers, deeds, invoices. That's the meaning of supported by proper documents. Meaning you have to give render proper accounts means what? Not just giving some journal entry. You have to give supporting documents also, is what was decided in this case law. Exam point of view, okay, not that important. Done Indian Contract Act. Next we are starting with Sale of Goods Act. Directly we are going to Unit 2. Unit 1, no cases. So priest versus last. What is this, people? Whenever I have made quality or fitness, people, whenever I have told you my usage. So in this case, what happened? A went to a shop and said, I want to buy a flask. Now, why do we buy a flask? Flask is always purchased to keep hot water or cold water. So the person relied upon the judgment of the chemist, meaning the shopkeeper. So I told you my purpose and I relied upon your judgment. You gave a product. He went to home and poured boiling water, people. The water exploded. So people, it is an implied condition of quality or fitness. If it is not serving my purpose, people, I will hold you liable. So quality or fitness will come into picture, and I have to rely upon your judgment. If I have relied upon your judgment, people, you will be liable. Priest versus last. Implied condition, quality or fitness is the main thing. Bombay Burma Trading Corporation Limited versus Aga Mohammed Khalil Shirazi. Same thing, people. Quality or fitness. I have told you my purpose. So in this case, what happened, people? Meaning railway company, people, they placed an order with a furniture company. They said, we want certain wooden logs. We wanted certain wooden logs for using it as railway sleepers. Now, what do you mean by railway sleepers, people? Don't get confused with railway sleepers. Railway sleepers does not mean seats. Railway sleepers means those which are put on track. We'll have iron track. You can see wooden logs put like this. These are called as sleepers. So now there was a company which supplied these sleepers, people, but it was unfit for it. Why? It rained. The wood spoiled. When the purpose was told, railway sleepers, I know it is outdoor. Who will use it indoor? Da? So it was your duty to give it as per that. Again, people, what is it? It will come under specific purpose when it is communicated. Quality or fitness. It has to serve that purpose. Correct? Done. Unit 3, Lee versus Butler. Meaning what, people? Okay, case only. What is this? A told B that I'm selling my goods to you on hire purchase agreement. You have to pay me monthly installments. So this was there in the condition. It is hire purchase, it seems, and you have to pay me money on installments. And remember, you can never terminate the contract in between. Meaning you have to pay. You don't have a choice of going back. The question is, people, A gave goods to B. B further sold this goods to C. The question is this, people, is this a valid sale? Remember, if it is a hire purchase, people, until the last installment is paid, you can never become the owner. So in a hire purchase, sub-sale can never happen. So it will not be considered as a valid sale. But in this case, people, the seller had put one condition. What? It's a hire purchase agreement. It was written. Correct. Valid. But they had put one more condition also, people, that you cannot terminate the contract in between. Remember, hire purchase agreement can be terminated if any installment is not made. So the contract, the court read it as, even though you have named the contract as hire purchase, but the effect was not like that. The conditions was not like that. So they considered this contract not as a hire purchase. They considered it as a conditional sale and not as a hire purchase, even though you have named it, because your terms was not that of a hire purchase, and the sale made by B to C was considered as valid. Exam point of view, no, they won't. Mount DF Limited versus J&J Provisions, Unit 4. What are those, people? Nothing but sub-sale. Is it valid? Yes. A sold goods to B. B said, I don't have money now. I will further sell it to C. Whatever they pay, from that I will pay to you. Now, A sold, ownership was passed. This person also paid money, but this person did not pay the money. The question is, this person's right as unpaid seller, will it come to an end or will it continue? The answer is, people, remember, whenever you have agreed for a sub-sale, whether directly or indirectly, people, your right as an unpaid seller will come to an end. So this will be a valid sale. Mount DF Limited versus J&J Provisions. I hope it is clear. Done. Chapter 4, Unit 1. Nothing but Indian partnership, no much cases here. Santiranjan Das Gupta versus Dasiran Murzamul, KD Kamath and Co versus CIT. Both the cases, the case is on simple thing, whether is partnership there between the parties or not. So the court saw a lot of aspects and decided what is the true test of partnership. So whenever you're writing this case law, the main word provision you will be writing this case law for will be this true test of partnership. What and all will be seen? Of course, people, mutual agency, presence of bank accounts, profit sharing, business being present. A lot of things will be considered, and then only it will be said whether this is a partnership firm or not. Was what was decided in both the case laws. So whenever they're asking you any question on true test of partnership, then please feel free to quote in these two. This will be a superior case law. One is sufficient. So remember and go. More than sufficient. Unit 2, Vishnu Chandra versus Chandrika Prasad. In a partnership deed, there was one clause which said, a deed saying if they wants to dissociate from the partnership business. Meaning what, sir? If at all a person wants to disassociate from the partnership, meaning he wants to leave, he needs to give a notice. Now the question was, the words disassociate from the partnership. Let us imagine, are they referring to if A, B and C, if C wants to go away, he needs to give a notice? Is that what they are trying to tell? Or are they telling if C wants to put an end to the complete partnership firm, complete disassociation, he needs to give a notice? What is that they are trying to tell? Is it they are trying to tell if C gives a notice, he can go, or if C gives a notice, entire partnership firm will be dissolved? What is the intention of that word given in that agreement? The court interpreted it as they meant to say it is one partner going out, that is the intention, and not the entire firm coming to an end. Exam point of view, not important. Makora versus Northern Assurance Company Limited. What happened in this case? There was a person, Companies Act we have started, people. There was a person who has taken insurance on all the company's assets. All the assets of the company. But he has nominated himself as a nominee. So one day it so happened that all the assets of the company, there was a fire breakout. But when they went into the case, it was seen that this person has tried to show that assets belong to him and not to the company. And in this case, it was decided that separate legal entity concept, the assets will belong to the company, the money will also belong to the company only. So the contract was not validly taken. If you remember, people, contract of Uberima Fidus, you cannot hide any detail. Misrepresentations cannot happen. It will be fraud. So the contract was not valid and not binding on the insurance company. Was what this case law, Makaura versus Northern Assurance Company Limited. You will quote this case law for, you will quote it for what? Separate legal entity. Next one, of course, same case law, Salomon versus Salomon also. Whenever a company is formed, what happened in this case law? A person formed a company. A person formed a company. Now, this person is called as Salomon. So, he is also a shareholder in the company. And when a company wanted some money, after some time, company wanted some money. The company went and borrowed the money from banks also. And the company had borrowed money long back from this person also, Salomon also. So, Salomon also had given the company some money. So, the company had to repay loan to both. One is to outsiders, one is to Salomon. But Salomon people called himself as a secured creditor. Meaning what? Whenever repayment happens, the first priority will always be given to a secured creditor and not an unsecured creditor. So one fine day, the company went into liquidation. The company does not have sufficient money. Imagine like this, the company has 5,000 rupees left with it. In that 5,000, they have to give bankers 10,000 and they have to give Salomon another 10,000. But the money left with the company is only 5,000. who should the company give the money to? The bank said, hey Salomon, you and your company are one and the same. It is your responsibility to give the money to the outsiders first and then you take. In this case, it was decided, people, once the company is formed, it has a separate legal entity. It enjoys its own existence. So, bank and Salomon both are the same for the company. Both of them are outsiders. And the bank's loan was unsecured. And the Salomon's loan was secured. So Salomon enjoyed the priority. So he took the 5,000 rupees. Again, it is a principle. What is the main fact for? What is the conclusion? When you're writing the provision is for separate legal entity. Important from company law's point of view. Simple, done, done. Next one, Daimler Company Limited versus Continental Rubber Tires. This is a case law for people lifting of corporate wheel. Generally, people separate legal entity means company is different and shareholders are different. But whenever a company form of business is utilized to do something which is, fraudulent, unlawful, in such cases, people, we will lift the corporate wheel and we will say company and the shareholders are one and the same. One such case is, people, Daimler Company Limited versus Continental Tire and Rubber Company. In this case, what happened, people? There were certain citizens in Germany. There were some citizens in Germany. They opened a company. They incorporated a company in UK. This was into manufacturing tires. This company was supplying tires to another company in UK. All of a sudden, this company started saying, we do not want to buy the tires from your company. After having a 5-year contract, they started saying, we don't want your tires after 2 years. So when questioned why, the matter went to court. So they said, sir, we do not want to buy tires from this company because they are our alien enemies. But the company incorporated in UK said, let us imagine company A said, sir, we are not alien enemies. We are also registered in UK. They are also registered in UK. Why are we alien enemies? So company B said, no, sir. They are not alien enemies, but their shareholders are alien enemies. But company A said, sir, we are registered in UK. Separate legal entity, no. They are different. We are different. But company B proved that, people, sir, let us agree. What they said is true. And we will give money to this contractor. We will give mast money. Then, people, the company will start earning more and more profits. That time company will declare dividends. That means indirectly the money is going for German. People, this was happening during the World War time, people, where Germans and UK citizens had declared each other as their alien enemies. So in the court, it was decided that when the corporate wheel is lifted, the company and the shareholders are same. The corporate wheel was lifted. Yes, the company set aside this contract. Done. Jaggilal Kamlapat, Commissioner of Income Tax. What are these, people? If you guys remember, we had seen one case in our class, Dinsha Manekji Petit. What happened, people? This case, simple, people. One person formed a lot of companies he formed. Imagine, people, now I have money. Let us imagine I have 1 lakh rupees. If I directly invest in Infosys will declare me dividends. Now, whenever Infosys declares dividends, it's an income for me and hence I need to pay tax. Yes. So anyone would do it in the same way. But what did this person do? This also is called a case of Dinsha Manekji Petit. Same case, same facts also. What this person did? This person formed 3 dummy companies, shell companies, no activity at all. So whatever 1 lakh rupees he had, he further divided that money into various companies. Like I gave 40k, 30k to these companies. What will this company do? This company will further invest in various companies like Infosys, Tata, ITC. Now they are all dividend giving stocks. They will give dividend every year. They started giving dividends to these companies. So this company started earning profits. That means they should pay tax as per this country's rules. Now what did this person do in the top? Mastermind. He started taking all the profits that the companies made. He started taking those profits as loan. He started taking it. And he never repaid the loans to these companies because it is his companies only. 100% of shareholding was with him only. He never repaid. By which people, what did he do? He did tax evasion. Neither the companies paid. Neither did he pay. Why will he pay? What he got is loan. Will anyone pay tax on loan? No one will pay, no. So what did he do? He came up with a structure to evade tax. So in this case, it was decided, people, if at all. Now what happened? He never repaid the loan also. For these companies, it became bad debts. So no profit. Then no tax. So people, corporate wheel was lifted and said, this person and these dummy companies are one and the same. Whatever profits was made by this company, this person has to pay tax on it. Case law, Jaggilal Kamlapat versus Commissioner of Income Tax. Done. Yes, sir. Again, one more case law, people. Again, lifting of corporate wheel only. Workmen employed in Associated Rubber Industries Limited versus Associated Rubber Industries Limited. What happened in this case law? See here. There was a company A. There was a company B. So, company A had lot of workers. Now, as per the rules of the land, what did it say? Whenever a company earns good profits, whenever you earn good profit, it is of course because of your workers' hard work. Because of them only you would have earned money. So the rule said, people, whenever you make good profits, it is your duty to give good salaries, good commission to your employees also as bonus. Company A had also done some investments in various companies. I'm just giving you an example of one company. Now, of course, whenever I invest, even they will also give me returns like dividends, interest and all, because of which again my profits are going up. If my profit goes up, I should again give it back to my employees also. So what did company A do? Company A came up with a mastermind. They formed one dummy company called as company C. And whatever investments they made in company A's name, they transferred, they sold all that shares to company C. Now, who is the shareholder in company B? Not company A, company C. Now, all the dividends started going to company C, by which company A's profits started falling compared to previous year. The bonus of the employees also started falling compared to the previous year. Now the question is whether whatever the company did, the company C, is this valid or invalid? In this case, it was decided there is no difference between company A and company C. Company C was just created to evade some statutory obligation that is there in the law. So statutory obligation is nothing but people payment of bonus. To evade that, you created this dummy company, and hence these two people are one and the same. Corporate wheel lifted, people, and hence you are liable to give commission even on the profits earned by company C. Was the case law. Associated Rubber Industries case. Then next one. Merchandise Transport Limited versus British Transport Commission. What are the case law? Simple case law. Company A applied for certain licenses of its vehicles with British Transport Commission, like our RTO office. But there were some irregularities because of which the British Transport Commission cancelled the licenses of these vehicles forever in the name of Company A. Now, Company A, of course, cannot shut down their business. What did they do? They formed a subsidiary company. Because what did BTC say? In your name, you can never apply for licenses again going forward. So what did Company A do? Company A formed another company, subsidiary company, Company B. They applied for a license again in its subsidiary company's name.
The British Transport Commission rejected this also and said, a lifting of corporate wheel da. When I said you cannot do directly also, you cannot do it indirectly also da. You both are same only. Again people, lifting of corporate wheel, when a subsidiary is used as an agent of the holding company, lifting of corporate wheel, even this license was also rejected. Clear? Next one, sir, Gifford Motor Company Limited versus Horn. Again, lifting of corporate wheel, people. Meaning, if at all you are trying to evade any provision of law or any legal obligation or any contractual obligation, to avoid it, or fraud, if you are entering into any or if you are opening a company, it will be considered as invalid. In this case, what happened, people? A company called as Gifford Motor Company, they hired one person as their managing director, and this person was called as Horn. In his appointment letter, it was clearly written that if at all in the future, if you resign or if we remove you for the next 3 years, you are not supposed to do anything which will make our customers come to you. You are not supposed to do anything. After 6 months of him joining, people, some things did not work out between them, and Horn ended up being removed in the company. Now what did Horn do? Horn knew everything about this company. He started selling spare parts of the company. Gifford Motor Company sent a warning to Horn. Horn, there was a clear restriction for the next 3 years. You are not supposed to do anything which will make our customers come to you. So selling us spare parts, our customers are coming to you. You are not supposed to do that. Now what did Horn do? Horn opened one company. Imagine people, H Limited. He made the shareholders as his wife and his friend were the shareholders. Whatever he tells people, they will listen. That was the agreement. Now what happened, people? The company H Limited started selling the spare parts of Gifford Motor Company. This time, people, Gifford Motor Company's patience was tested. They filed directly a case against H Limited saying, hey Horn, you are only doing something indirectly. Horn said, hey, what are you telling? The restriction was with me. You entered into a clause with me that I am not supposed to attract. H Limited is a separate legal entity. You do not have any agreement with them. In the case, it was decided Horn and H Limited are one and the same. This person is trying to do something indirectly. And hence, people, in this case, lifting of corporate will to avoid some contractual obligation to do fraud. Lifting of, see, these cases, cut, copy, paste will come here exam. Story also will repeat. Are you getting? If I am not wrong, people, from this case law series, you will at least get 10 marks, people. At least I am telling you. Bare minimum. Yeah? Okay. Next one. Narendra Kumar Agarwal versus Saroj Malu. Exam point of view, not important. Again, lifting of corporate wheel only, people. If at all you guys have formed any company for doing any business which is unlawful, and to find that out, if we want, we can lift the corporate wheel, was what discussed in this particular case law. Not important from exam point of view, but this is the judgment. Separate legal entity to find out unlawful activities being conducted by the company. Lifting of corporate wheel can be done. Simple, done. Harinagar Sugar Mills Limited versus SS Junjunwala. For your level, this case and all is not required at all. But I mean, they've just put it. But yes, what is this case, people? Remember, it's nothing but in a company, people, there will be two types of shareholders. One is called as majority shareholders. One is called as minority shareholders. Majority means, people, let us imagine Reliance, the promoters, Mukesh Ambani family is majority shareholders. Rest of us, like public, we can be considered as minority shareholders. Minority shareholders. So, in this case, it was decided, people. Remember, generally the company will always follow whatever the majority shareholders say, because they will be holding 75% of it, no doubt. But is it always like that? Whatever majority says, should we always follow that only? Should we completely ignore minority? The answer is no. In Companies Act 2013, earlier and all, yes, that was the case. Whatever majority say, that will only prevail. But in Companies Act 2013, that is not the case. Whatever minority says, even that will also prevail as long as they are right. So even minority shareholders are also given right to speak. This is under Companies Act 2013. For your level, not at all required. Yes. State Trading Corporation of India Limited versus Commercial Tax Officer Visakhapatnam. In this case, what happened? Okay, I'll tell you what is the summary. The summary was, people, the question in this particular case was whether you guys are considering company as a separate legal person. Agreed? Yes, it's a separate legal person. First of all, is company considered as a person? Yes, it's an artificial person. Now my question is, if I am a person, now Sai Kumar, me, I enjoy something called as people fundamental rights as a citizen of India. Now the question is, people, will the fundamental rights, can even a company enjoy? Forget about that. Can even, okay, I am considered as citizen of India. Can a company be considered as citizen of India? You're a person like me. Can you be considered a citizen like me? In this case, it was decided. Remember, citizenship is only for individuals and not for corporates. That's all. And hence, can you enjoy fundamental rights? No. It is only for citizens, not for corporates. So a company cannot be considered a citizen, and hence you cannot enjoy any fundamental rights given in the Constitution of India. Exam point of view, not that important. Spencer and Company Limited versus Commissioner of Wealth Tax. What happened, people, in this? Again, people, same thing. Dinshaw Manekji Petit, same thing. Evasion of tax, lifting of corporate wheel. Nothing else will change. So Spencer and Company Limited versus Commissioner of Wealth Tax. Cut, copy, paste. So whenever they're asking you for evasion of tax, feel free to write this case law. It will be valid. Spencer and Company Limited versus Commissioner of Wealth Tax. Heavy Engineering Mazdoor Union versus State of Bihar. Sir, in this case, what happened, people? Sir, there is a central government, sir. Central government is holding 55% of shares in a company called XYZ Limited. Now, we all know that this is a government company. Yes. Now, my question is, people, the workers of this government company, should we consider them as government employees? Should you consider them as government employees because they are working for government only, no? Central government only, no? Remember, people, even though you are a government company, you will not be considered as government employee. That means what, people? You cannot consider XYZ Limited as government only. When the company is incorporated, it is a separate legal entity. You cannot consider XYZ Limited as government. It's a government company. End of the day, company only. That means what? You cannot consider it as one of the, you cannot consider it as also one of the government. So I cannot consider them as government employees, and hence pension, all those rules will not apply. So in this case, there was a fight and argument that when a shares are held by government in a government company, then that government company will also be considered as government. And hence all the employees will be government employees. And whatever laws applies to government will apply to government company also. Answer is no. It's end of the day company which is held by government. The employees will not become government employees, and all that was what was decided in this case law. Case law, again, principle is for separate legal entity. No matter whether you are the shareholder or government is the shareholder, company is company only. Clear? Separate from its shareholder. Borland's trustee versus Steel Brothers and Company Limited. In this case, what was decided? Again, not required for us. But people, doctrine of constructive notice. In this case, what happened, people? A shareholder had, once the articles of association is registered, the shareholders are bound to the company. So in the articles of association, people, there was one rule. What does it say? That if a company, imagine if a person becomes insolvent at any given point of time, if a person becomes insolvent, at what price the shares should be sold will be decided by the company and not by the insolvent. This condition was there in the articles of association. So just like that, people, a person became insolvent also. So on behalf of him, an official liquidator was appointed to come and sell all the shares of this person. All the assets of this person. One of the asset was also shares. So the official liquidator wanted to sell the shares at 150 rupees per share. But the company said, no, nothing doing. You cannot sell it more than 100 rupees per share. So the company said, no, we have clearly written in articles of association, you cannot go beyond what is given in articles. The liquidator is coming and saying that, no, it's my right. When I have a share, it is my right. I will sell it at whatever price I want. You as a company cannot dictate it. In this case, it was decided, people, remember, whenever the articles of associations is registered, the shareholders are bound to the company. The company is bound to the shareholders. Whatever is written in articles of association, you are bound by it. And hence, yes, in this case, you cannot sell for a price higher than 100, which is given in our articles of association. And you are bound by it. That is what was discussed and decided in this case law. Exam point of view, okay, not that important, you can ignore. Ashbury Railway Carriage Company and Iron Company Limited. What is this, people? Doctrine of ultra wires. Simple, I'll tell you in other terms. Imagine, sir, there was a company whose whose MOA, object clause said we can do any contract which is railway construction, railway contracts, all that we can enter into. The directors of a company entered into a contract to give loan for someone else to build a railway company. So our directors enter into a contract to give loan to build a railway company to someone else. What did we give? We gave a loan. The shareholders came and said, people, whatever you guys entered into a contract to give loan to the railway company is ultra wires. The directors are saying, no, how is that? How is it ultra wires? It cannot be considered as ultra wires. Because, people, what has happened here? How can it be considered as ultra wires, people? Yeah, directors are trying to say that it is not considered as ultra wires transaction. But people, remember, end of the day, we are giving loan for a other company to build a railway company. Giving loan is a finance transaction which can be done only by people, a banking company. So did the directors, whatever they do, was it valid? Answer is no, people. It was a ultra wires transaction. They went beyond their object clause. And hence it does not bind the company. It is an ultra wires transaction. Understood? Again, Tumte started. Okay, next case, people. Royal British Bank versus Turkey. In this case, what happened, people? The company, in its articles of association, has clearly written the company's directors cannot borrow loan beyond an amount given and agreed in the company's shareholders meeting. Whatever is the maximum limit agreed in the shareholders meeting, whatever is the maximum limit that is agreed by the shareholders in the meeting, the company cannot borrow. What nonsense.
It was audible there. Yeah. So it was clearly given people in the articles of association that the company cannot borrow, the directors cannot borrow loan beyond the number that is mentioned in the company's general meeting. Whatever the shareholders have authorized in the general meeting, the directors cannot borrow money beyond that. So where will it be agreed? It will be agreed in the general meeting of the shareholders. But wonder what happened, people. The directors of the company went and borrowed money from a bank called as Royal British Bank. How much did they borrow? They borrowed, let us imagine, 10 lakh rupees, which is repayment of 1 year. After 1 year, people, 1 year is done. The company did not repay the money. The company did not repay the money. Now the question was, people, what did the company say? When the Royal British Bank came for asking the money back, the company said, people, sir, so sorry, we are not liable to pay 10 lakh because the money that we had authorized in our general meeting was only 5 lakh. Why did you guys give our directors beyond 5 lakh? So people, in this case, it was decided, people, that are the outsiders allowed to attend your meetings? No. So how will they be aware of whatever was discussed in your meetings? So people, in this case, it was decided, people, the company will not, the bank, the outsiders will not be liable for whatever they are not aware of, and that is only called as, people, doctrine of indoor management. Outsiders are not allowed to come into this meeting. So how will I know what was agreed in this meeting? So what would be the right way? The right way is, people, to put it in AOA. Say that your directors cannot borrow beyond 5 lakh. Put it there. Yes? Agreed? Yes. So in this case, the bank was able to recover the money under the rule of doctrine of indoor management. Next one, people. Ganesha. I hope you guys are able to hear that background noise. You guys are in the background there when 500 speakers are playing top 10. I hope you guys are not listening to that. The voice is not. SS Rajkumar versus Perfect Castings Private Limited. In this case, what happened, people? Nothing but a contract was entered into violation of restriction in the articles. When challenged, the outsider argued that they were unaware of the restrictions. What is that? A company's directors entered into a contract with the outsider in violation of its articles of association. So, when challenged in the court, they said that as an outsiders, we do not know what is there in the articles. How will we know? Doctrine of constructive notice, people, ignorance of law is not an excuse. If the documents are sitting in the public domain, whether you read it or not, it is always understood that you have read the documents. Principle, people, doctrine of constructive notice. Harvard versus Patent Ivory Manufacturing Company Limited. What is this, people? This is a case for exception of doctrine of indoor management. What is this, people? Nothing but in a company shareholders meeting, it was decided that a company cannot, the directors cannot borrow any loan without asking shareholders beyond 5 lakh rupees. Was it given in AOA? No. Was it given in MOA? No. But where was it written? It was nowhere written, but it was decided in the shareholders meeting, for which even the directors are also one of the participants. They also participate. No. Now in this case, what happened, people? When the company wanted money, one of its directors only gave loan. 10 lakh rupees was given by the director to the company. The question is, people, he said that's a doctrine of indoor management. In this case, it was said, people, it does not protect the person who is aware, who is having the knowledge of the irregularity. You know that you are not supposed to borrow more than 5 lakh. You are aware of it. And if you give 10 lakh, people, whether the company will be, liable to pay it or not, you are aware of it. In the previous case, Karsandas rule, it was outsider. Here you are aware. And you are not entitled for the money back. It is only 5 lakh rupees. But remember, I told you in Mohri BB case also, there is something called as doctrine of equity. If company has taken the benefit people, it is your responsibility to return that. You cannot say I will take benefit of 10 lakh and I am not liable to repay. That you cannot say. That will always be your right and it is your liability. Clear? Morris versus Canson, nothing but people, this is same. Morris versus Canson is the same case law for Rubin versus Great Bengal Consolidated. What is that people? Exception to indoor management. In this case, what happened? One of the person applied for some shares in the company. One of the person applied for some shares in the company. In that company, there was one secretary. This person did a forgery of the signature of their directors. And he issued the share certificate to this person. Later when the company got to know, they said, no, this transaction is invalid. He is an innocent buyer. Now the question was whether he will get the shares or not. So in this case, it was decided, people, always remember, forgery will never give anyone a right. You can file a case on the secretary, that's a different story, but the company will not be liable or responsible for this act. So whether will this be liable? Answer is no, it will not bind the company. Exception to doctrine of indoor management. No matter how innocent you are, company will not be liable for this contract. Is clear? That is Rubin versus Great Bengal Consolidated. Same thing is this also. Which one? Morris versus Canson. Ignore this. Remember Rubin versus Great Bengal Consolidated. Next one, people. Anand Bihari Lal versus Dinsha and Co. Again, one of the example for people. Your exception of doctrine of indoor management is nothing but suspicion of irregularity. Meaning what, people? Whenever you guys are entering into a contract with a company. In this case, what happened? One person wanted to buy a property from a company. He wanted to buy a property from a company. He went and gave money. He entered into a contract. He signed everything. Contract, everything was made on behalf of the company by a person. And who is this person? This person is an accountant. Now, people, it is your duty to check people whether with whomsoever you guys are entering into a contract, it is your duty to check whether that person has a right to enter into a contract on behalf of a company or not. You cannot say doctrine of indoor management for everything. In this case, the accountant of the company sold the property to an outsider. Can it bind the company? Answer is no, exception to doctrine of indoor management. Case law, people, Anand Bihari Lal versus Dinsha and Co. And the last case, people, is Harbottle and Co. versus Northern Law and Wills Limited. Nothing but, people, case law is similar to whatever is seen in Anand Bihari Lal, notice of irregularity. Meaning, people, when you know that something is not right and you have not made your enough research, in such case, companies will not be held liable. That is these cases, and luckily we are done. In the background, I don't know, they are going to kill me with the sound, I think so. I don't know why all this, but yes. Okay. Hopefully, yes, the same God, or the God, whatever we believe in, hopefully gives us the marks that we guys expect and anticipate. And I hope this session made some sense to you. And I'm screaming here because of the background music. But do let me know your comments. I'll be the most happiest person to know how it helped you. And wish you guys the best in tomorrow, day after tomorrow. Let us do your RTPs and MTPs. And the last day will be for the practicing of your writing answers. So thank you so much, people. I hope it was a very good quick revision of all the cases that is there in your ICAI syllabus. Thank you. See you all. Bye-bye.